Welcome to the Care Social, where we discuss the biggest topics in social care right now. Whether you're a health and social care provider, a frontline worker, or just passionate about making a difference, we're here to bring you expert discussions, insights, and real stories from the sector. I'm Barry, Content Operations and Delivery Manager here at QCS. In this episode of the Care Social, we're joined by Laura Shelton, partner in the healthcare team for and on behalf of HCR Law. Today we're talking all things challenging a CQC inspection. So thanks for taking time to speak to me today, Laura.
No problem, Barry. Thanks for having me.
So let's dive straight in then, because it's a really big topic right now. We're seeing constant people putting on LinkedIn and Facebook group where they're having really difficult time with the CQC, whether it's just an inspection, communication, or as a result of an inspection, they're not happy with what's been provided. Do you want to start by introducing yourself? Give us a little bit about your experience in supporting social care providers with CQC, and in what situations might providers consider formally challenging the outcome of CQC inspections?
Sure, no problem. Well, as you said, I'm Laura Shelton. I am now a partner in the healthcare team at HCR Law. Myself and my team joined HCR Law just over a year ago. In May last year, the Redoubts team came over and joined up with HCR Law's healthcare team. So we are now a full service healthcare team. My team looks after the regulatory challenges. We also have corporate and real estate and employment specialists, all specifically for healthcare. So that's been a really exciting time for us. In terms of my experience in supporting care providers with CQC challenges, I mean, that has been my bread and butter essentially for the last 10 years now. Really honed a specialist practice in that during my time at Redoubts, and I would say it is the majority of my work. So I've assisted providers with all sorts of challenges, CQC inspection challenges, which is what we're mainly going to focus on today, but also things like warning notices, registration cases. I've had a few successful registration cases at the Care Standards Tribunal. I've also assisted providers where poor inspections have led to enforcement, and they've ended up at the Care Standards Tribunal for cancellation proceedings. So full spectrum, basically anything to do with CQC and all the ancillary things that touch that, like safeguarding, inquests, all that kind of thing. So well versed in it. Probably should say at the outset, as a bit of a disclaimer, I'm really a distress purchase for providers of health and social care. It's not often that a provider will ring me up to tell me they've had a great time with the CQC. So I don't want anything that I'm saying today to come across as sort of CQC bashing, as it were. It's just really that's my experience. I help when providers are having difficulty, so I'll be able to give you some insight into that side of the coin. And I guess following on with your second question, which is in what situations might a provider consider challenging the outcome of a CQC inspection? That's, as I say, my bread and butter. I get asked that question all the time. There's a variety of reasons. The most obvious is ratings, because everyone, your commissioners, the people that use your service, families that are looking to place are reliant on the ratings that are published. And the hope is that that information that's put in the public domain is accurate and up to date. And where providers might consider challenging is where they think those ratings don't reflect the quality of the service or how it was on the day when the inspectors came. So I'd say that's the main time when providers want to challenge reports. We also end up doing it as part of enforcement action, sometimes if there's been a warning notice or even a notice of proposal, or as I had recently, a Section 31 action, and that's the CQC's urgent proceedings. They were looking to impose conditions of registration on the back of an inspection, and I worked with a provider to challenge both the Section 31 and the inspection report to have them both overturned essentially. So yeah, those are the circumstances. I think because a lot of providers find themselves in a situation where commissioners won't commission if they have requires improvement or less, and the fact that providers aren't inspected now. Well, nobody really knows when they're going to be re-inspected. There used to be really clear re-inspection timeframes, but now you don't know, and there's numerous providers. I mean, one of the most popular questions I get asked when I go out and about to events is, I've been rated RI, I haven't been inspected for 18 months, 2 years, 2.5 years. How do I get CQC back out to re-inspect? And I think if you're sitting with a rating that's not reflective of your service, obviously you want to think about challenging that so that correct information is in the public domain.
And it's one of the big challenges at the minute where, because CQC are assessing on risk predominantly still, so they're only going out to the providers that are flagging up on the risk modules. Those that have made improvements and want CQC to come out and re-inspect because the RI is infecting their ratings and they've made improvements, they just can't get them out. CQC won't engage. It's a difficult one. I expect you're really, really busy at the minute. So what would be the first steps then that a provider should take if they disagree with an inspection report or a rating? What do you say that the first steps they should consider?
Well, I guess it depends when they get sort of notice that if you're talking about as soon as they receive the report, then providers, first of all, shouldn't panic, and they should remember that they do have a period of time. It's supposed to be 10 working days, but I think in reality, with the portal and the way deadlines are set, providers are actually getting a little bit longer. But before it gets to that stage, if a provider is not happy with the way that an inspection is going, because sometimes, and people do phone me up while the inspectors are there to say, this isn't going as we've expected, they're not looking at the documents we want them to look at, or there's a whole variety of things. There can be conduct issues, etc. I think it is important to try and maintain an open and professional and transparent dialogue with the inspectors while they are in your service, and do what you can, what's within your power, to try and get them to look at the documents or to give you some feedback so that you can provide information about risks, etc. CQC's guidance is clear that if there are really serious risks that are raised during the inspection, then the inspectors should be raising that with you. However, one of the biggest challenges I see when providers get their report is that the first time they've had any notice of an alleged serious incident is when it's come out in the draft inspection report. And that's not acceptable. It's not good enough for the provider. If someone is really at risk, they should be told about it so that they can sort it out on the day. So first steps. If it's during the inspection, try your very best. If there are circumstances where, it is out with your control, but you remain professional, and then keep a note of anything that you're not happy with. Ask for feedback, because it's still the case that not everyone's getting feedback, or they're getting feedback months and months after an inspection, which again isn't really helpful to the provider. But if you've just received your report, don't panic. Start to think about the evidence that you might have to gather to respond to the factual accuracies. At that point, you may consider, now you don't have to do this, but you may consider getting some independent support from the likes of myself or consultants or otherwise.
There's a lot of providers out there that are scared, aren't they? Because I've been on the receiving end of really difficult inspectors coming into your service. They won't engage with you. You do want them to look at certain things, and you can sit there with the CQC evidence folder with all these amazing things in, and they won't look at it because they've already got their plan of inspection out. And even when you try to get them to look at it afterwards, they just refuse to engage. Can you briefly explain then the different routes available for somebody that's either having a difficult inspection or as a result of that? So can you briefly explain the different routes available for challenging a CQC outcome, like factual accuracies, formal appeals?
Sure. Yeah, of course. And just to pick up on that, when you're talking about, not being able to get inspectors to look at certain things, etc. I think another difficulty that's come through with the single assessment framework, which was supposed to make inspections more transparent and more in real time, what I have experienced with providers is that CQC are coming out and not actually spending that much time in the service, and then asking for heaps and heaps and heaps of documentation afterwards with no context or without the appropriate knowledge and skills to look through the care planning systems. And that's where things are coming a bit unstuck. And that can be tricky to manage. And I have had to help a provider go through that. And ultimately, in that case, we had to do factual accuracy comments, but we also did a complaint. And I guess those are the routes that I would talk about now in terms of thinking about challenge. So there's no formal care standards procedure in relation to inspections per se. The route to challenge your rating and to challenge your inspection is through the factual accuracy process. Now, over the years that I've done this, when I first started doing this, CQC used to come back in responses and say, oh, you can't challenge the ratings at factual accuracy stage. That's a matter for rating review. Now, that's not correct. Now, we haven't seen that explicitly for a while, but it is to remind providers that the factual accuracy process, which is now on the portal for adult social care providers, certainly, is not just about, you said there were 10 beds and there's actually 15, the door was green and red. It's not just pure factual accuracy. It's the factual accuracies, it's any alleged breaches of regulation, because of course that is what will feed into any potential enforcement action. And it's also the rating, and you need to try and do that all as part of the factual accuracy challenge. And that has changed a lot over the time I've been doing this, and especially recently with the single assessment framework, and even more recently with the move from scoring at evidence category level to quality statement level. So you have to do your response on the portal. There's a character limit, which is 2,000 words. 2,000 characters, which is about 300 words. That's really tricky, but you can upload additional information on supporting documents. It does make it all very bitty. And so what I would say is make sure you leave yourself plenty of time. So the first stage in the process would be your factual accuracy comments. And that is where you really want to throw everything at it, because that's the opportunity to get the changes to the ratings and the alleged breaches, etc. And just following up on what you said about providers not having their information taken into account, if there is information that was available at the time of the inspection, or even evidence of improvement since the inspection, CQC's own guidance, which is on their website, and I can supply links if it's helpful for listeners, it's on their website, says that providers can provide this evidence. It might not necessarily impact the rating, but that depends on a case-by-case basis. But you should consider adding it at that time. Now, one would hope that would be the end of the road. You would submit your factual accuracy comments, CQC would review them. Yeah. Someone independent at CQC should review them. Again, we've been back and forwards in various cases over the years. This was sort of the fallout of a judicial review from quite some time ago now. It was the SSP case, which related to factual accuracy comments and comments that the judge made about, what's the point in having the process if it's not independent, if someone independent doesn't look at it, if in that case it was where providers had made comments but the comments weren't taken into account, and then there was no independent mechanism to make sure they had been looked at. And CQC added in a layer to the process where someone independent at CQC that hadn't been involved in this inspection would review the response to the factual accuracy comments. However, my understanding is that the initial comments are still dealt with by the inspection team that dealt with the inspection, and then it's reviewed. Now, as I say, one would hope that would be the end of the road, but quite often we do see that CQC have come back, they've either only changed some wording or they've not made the changes that the provider want. It varies on a case-by-case basis, but if that is the case, you can submit what's called a rating review. Now, CQC used to publish statistics on their website about how many rating reviews were successful. I had a quick look this morning and I could no longer see that data, but it used to be quite depressing. In all the years that I've done this, I have had, I think, 2 or 3 successful rating reviews, and considering I've been doing it for 10 years. And what I would say to that is it means that, the real ground for challenge is the factual accuracy stage. And the reason for that is that rating reviews are specifically limited to procedural errors, and they say that the CQC won't look at things that you just think are unfair, judgments, etc. You should challenge that as part of the factual accuracy process. However, if you are needing to challenge further down the line, and we have done this with providers, so if your factual accuracy is not been considered or hasn't come out the way you want it to, if you've then done a rating review and it's not been successful, then you can consider judicial review. Now, that is obviously a court procedure, and that's a public law procedure where the court is essentially looking at the way in which the CQC has made its decision. Now, the court won't replace the judgment of CQC, but it may find that there has been an error. So, for example, there's a whole load of different errors they could find, like fettering their discretion, or if there's been some bias, they may then remit the case back for CQC to be considered. We've dealt with a number of judicial reviews over the years. The vast majority of them don't actually ever reach the court, and they settle, or they don't get permission or whatever. Generally speaking, the ones that we've had have settled outside of court, but that's another mechanism. But the reason I sort of spoke about that hand in hand with rating reviews is part of the pre-action procedure for judicial review requires you to exhaust local remedies, essentially. So you should really have done your factual accuracy comments and tried a rating review. Factual accuracy comments, you get minimum 10 working days, although as I say, with the portal, we have seen that providers have been getting a little bit longer. Rating review, you get 15 working days from the date the report is published. And when you submit a rating review, something comes up on the CQC's website so that providers and people looking at the website know that it is being challenged. So that's 15 working days. And then if you are considering judicial review, it's a very strict 3-month time limit, and that's a 3-month outside maximum limit. Really, the courts are looking for you to bring those actions pretty much as soon as you're aware of them. So in all cases, there's not a huge amount of time.
Before the portal, the provider that I worked for previously, We submitted a 78-page factual accuracy report. We found lots wrong with it. We were really unhappy with the inspection, and CQC didn't take any aspect of it into account. We just got a really blunt response. So it's like, nah, get on with it. We sat down at that time and thought, do we invest in spending a lot of money going down the legal route? Or do we invest that money back into the service, to address the issues? Because it's there now. It's out in the public domain. People can see it. It's a real hard decision for lots of providers because of the cost involved. What are the typical costs involved in challenging a CQC report, both with and without legal support?
Yeah, it's a tricky one. I'm going to give you a typical lawyer answer. It depends how long's a piece of string. But you are right. And if you start at the sort of the wider end of the spectrum, looking at judicial review, obviously that is expensive. And you do have to think about, as you have said and given a really good example of, bearing in mind also the timescales that would be involved in court action, whether it is better to reinvest the money in the service, or whether the report is so bad or the rating is so bad or the behaviour of the inspectors in relation to the way they've exercised their duty is so bad that you want to do something about it. And the cases that tend to get all the way to court are those where, the impact of not challenging outweighs the cost, essentially. But sometimes with that really difficult rating of requires improvement, providers might think, it's not worth it. Let's spend the money on getting some independent consultants in. Let's really bring it up to speed and draw a line under it. And that's ultimately a commercial decision, but that is one that we can help you to make, and we can give you advice on prospects and how much it's likely to cost along the way. But obviously there's a lot of subjectivity at CQC, and it really depends who looks at your challenge. But that's not a reason not to do it. I mean, on cost, clearly if you do it yourself, there will be certain costs involved in terms of the time, because you will need some senior people that were involved in the inspection itself, and perhaps sort of regional managers, or depending on your structure, your quality managers, etc. Really making sure you get the challenge right. And as I say, you do get 10 working days, which feels like quite a long time, but you've talked about a 78-page challenge. If there's lots to challenge, these documents become unwieldy quite quickly. It becomes quite a lot of work. So it's not to say it's free to do it yourself. It is time consuming, and sometimes the cost of getting someone independent like myself to do it frees up that time for the people that are in the service to be dealing with the issues that are there. We have a variety of fee ranges. Now obviously I'm a partner, so I wouldn't be doing every single bit of it. It's not cost effective for clients to pay my hourly rate, but we certainly in our team have a full range of fee earners at different levels of cost, and we definitely make sure we pitch it at the right level with the right level of supervision. We can also offer fixed fees, which gives providers some certainty so that they know upfront, and we would do that on a case-by-case basis because obviously everyone wants to challenge different amounts. So for example, someone challenging 5 domains that are inadequate with tons of breaches, that's going to take more time than someone that wants to just challenge 1 or 2 domains. But we would have a sensible discussion with you at the outset, bearing in mind, your budget, etc., and pitch it at the right level so that it's not a surprise when you get the bill at the end of the day. If you have to go through to the court process, then that can obviously be more expensive, but it is done in stages, and we could obviously talk about that as we go through. What I would say when you're thinking about whether it's worth it or not, I think if you have lots of regulatory breaches, these are the type of things that can lead to enforcement action down the line. So you want to be trying to nip that in the bud at an early stage if you can. You also want to think of the wider position. Is this going to impact people commissioning? Is it going to be a stranglehold on new placements at the service? And in those circumstances, you might be more inclined to spend the money. But it is an individual case-by-case basis. And we're always, always, always more than happy to have an initial chat with providers. We work with lots of care associations where we run helplines, we offer discounts. But, I'm always happy to have an initial chat to see whether there's any legs to it. Yeah. Obviously, I can't make any guarantees. If I could guarantee good outcomes, I'd be retired by now. But
it's one of those things as well, isn't it? It depends on your business makeup that you just alluded to there. The majority of people we support are those single owners, the nominated individual, registered manager and provider all in one. So they haven't got the benefit of regional managers and quality directors and everything that can all come and descend on. So it really does depend on your business model and the size of your company in order to do that. And I think one of the things we've seen quite a lot recently, and again from experience, is where people take on a new business. So they will acquire an existing care home, and we got caught out by the regulatory history.
Yes.
So even though service that we took on was rated good, there were still some things in there that the inspector had put, you may want to note this, or provider needs to do this and needs to do that. We got bitten by, as the new provider, not putting an action plan on based on the previous rating from a previous provider. And that seems to be creeping in a lot more, and people get caught out by that. There's lots of new and interesting ways that CQC are adapting.
Yeah, that lots of horizon scanning has to be done, and you have to really think about the different things that you could do to challenge, but also to be aware for the next time round. Like you're saying, regulatory history is something that comes up a lot. I had it in a recent challenge that we were dealing with, and we did address that through the factual accuracy. How fair is it to word it in this way in the report? It's really misleading. You need to make it clearer to people who are using the service that this was a new provider, that's an old provider issue. So yes, lots. And sometimes, I guess, if you're thinking about and again, thinking about those sort of single home operators that perhaps aren't doing this all the time. I am doing this all the time. My team are doing it all the time. We're thinking about all these different things that you can possibly challenge. Sometimes a provider reading through a report might not think there's certain things that they can say, make comments about, and that's where we can give you a bit of a steer.
Having that ear that providers can ring up and have that initial, should we, shouldn't we? So it leads into other situations where you would advise a provider not to challenge. What kind of things would you advise?
Do you know, I don't know that I would ever explicitly, would I ever explicitly say not to challenge? Well, there are cases where people come to me and things are, on the face of it, unfair and unjust, and they're really not happy with it, and then I go away. Well, I say to them, let's have a look at it. What evidence have you got? And then they go away and they speak to people in the service, and that was the situation on the day, and that was what the inspector saw, and that was what they were told. So what I wouldn't ever do is encourage and support and take fees from someone who's challenging for the sake of challenging. I would have to be thinking about always, is there prospects? Now, if you have just had a bad inspection, if the service isn't where you think it would be, and that may be because you're a bit higher up, you're not involved in the service day to day, and maybe it's eye-opening for you as the provider, we'd be having a frank chat about prospects and the benefits and the cost involved, and that would certainly be a situation where I would be saying, your money's better spent in getting your house in order, getting your ducks in a row for next time. That's it. It doesn't happen that often. It does happen, but not that frequently. There's usually something that providers want to go back with, but it's always worth thinking about. And actually, it comes around more in relation to rating reviews, and I probably should highlight this, or should have highlighted it when I spoke about it. But with rating reviews, unlike factual accuracy comments, I've never seen it with that, but with rating reviews, ratings can go up as well as down. So if you need to be really careful and think about what you're challenging and the evidence that you've got available.
Absolutely.
So that would be another situation where I would be saying to providers, we want to be a wee bit careful here. Maybe you've just got away with it. Let's just let sleeping dogs lie. Yeah. And so again, that can sometimes be the benefit of a frank discussion, and I'm fairly thick-skinned when it comes to this type of thing, because I know sometimes providers do want me just to say, oh yeah, it'll be fine, we'll challenge it, and you'll have a magic wand. I have to be practical, and I have to manage expectations, and these are all the things that we would be looking at. So yeah, in summary, if you don't have evidence to support it, then you'll be, it's probably not worth your while.
But I think that's the bit that people need, isn't it? It's that impartial view.
Yeah.
We weren't involved in the inspection. We weren't sat there on the ground. You're looking from the outside in and say, well, actually, this is good. That's not great. Having that little bit of a steer can be really useful.
Yeah.
So realistically then, how often a challenge is successful, and what factors can improve the chances of a successful challenge?
That's, again, a question I get asked frequently, and quite reasonably, because people want to know when they're spending this money, what are the prospects of success. What we can't and don't do is give percentage chances. There's just so many variable factors in terms of how much you're challenging, what evidence you have available, who looks at it. Across my time, I have had a whole spectrum of results. I had one service that was 5 inadequates got all the domains up, got all the regulatory breaches removed. I have had inspection reports where the report was, I think off the top of my head, it was either requires improvement or inadequate, but as a result of our factual accuracy comments, the whole report was scrapped and they were re-inspected. I've had more sort of nuanced results where perhaps providers haven't had a change in the rating, but they've had things like regulatory breaches removed, which on the face of it, sometimes to a provider doesn't really feel like a win all the time, but it removes the need for an action plan. It removes the wording that you've got that breach, but most importantly, it removes the risk that they're then going to serve a warning notice or more enforcement action or talk about your regulatory history as having all these breaches. Yeah. We do, and I'll be completely frank, we do get situations where not much has changed, and I find it just as frustrating as the providers do. But what I would say is it's always really important to put your position on record with the CQC, especially if there's situations where there's really long periods in between re-inspection and there is risk of enforcement action. So just because you maybe haven't had the outcome you wanted, the fact that you've put your position on record means it's there. And there are things you can do as a provider. You can write to your stakeholders, your family members, you can give some narrative about the report. But I appreciate that's a kind of roundabout way. It depends. And I think you probably want to know what factors lead into prospects of success. And it's a little bit like I spoke about with the last question. The more evidence you have of to support the position that you're saying, if inaccuracies, documents not looked at. And we do actually find that's a lot easier these days, because when a particular case I'm thinking of, CQC came in, didn't really know how to look through the electronic record system. It's issued a draft report with all these things saying this wasn't in place, that wasn't in place, the next thing wasn't in place. In actual fact, we had all that, and if they'd asked the staff team at the time, they could have been shown, but they didn't. And those are the types of cases where you see change a bit more easily. But also, we can get involved and do really detailed legal submissions about regulatory breaches to get rid of them. So prospects will depend on that as well. And that's all something that we would be advising you on when we first speak about the challenge, when we look about the evidence and as we're going through. But sadly, no magic wand to guarantee a good result. Yeah. But what I would say is, and it is the case where you have seen these cases go all the way to judicial review, or whether there's been enforcement action in the tribunal, it is the case that frequently the factual accuracy comments form part of the court papers in these documents. So if there is a chance that you're going to be going down that road, in my view, it's helpful to have some evidence of what you've done to try and put your own position forward and put things right, because that can help further down the line.
In terms of advice for providers then, what can providers prepare better to reduce the risk of needing to challenge afterwards? One of my examples of this one is about preparing staff better for inspections, because staff have this fear of inspectors. And again, one of my recent experiences where the inspector made a judgment that we didn't have enough staff on shift because staff were really, really busy. In reality, the staff really didn't want to get talking to CQC, so every time they saw the inspector, they dashed off to another part of the building. So it made it look as if they were really busy. The view was not enough staff. It's stuff like that. So what can providers do then to get the staff team and the service ready for inspections?
Yeah. I think you've hit the nail on the head there in terms of minimising risk of a poor inspection outcome and needing to challenge. It is really training staff and getting their buy-in. It's all very well for people at provider level and governance level to know the ins and outs of CQC and what to expect, but the people they're going to speak to are the people that are supporting your service users, and they need to be comfortable to do that. And it's, different people will take longer to become comfortable with that type of thing. And I really think it is worth providers investing in training their staff, from a very early stage and keeping them involved in the process, because you want them to be open and transparent with CQC. And it's not about coaching them to say certain things, but it's about giving them the confidence to give the best version of themselves. And also things like, and I see this a lot, if they're asked a question that they don't really understand, they won't say, can you explain, or can you repeat that, or can you give me some context to what you're meaning? It happens a lot around DOLs and capacity, where the provider will then find, of course, this person was trained and they did know what they were talking about, but they were just asked it in a way that wasn't super familiar to them. And it's to give providers the opportunity to train staff so that they can present the best version of themselves. What I would say, and I've always said this in terms of, gathering feedback, challenging your own systems through audits, etc. But with the single assessment framework, although they don't score at evidence category level, they still have the evidence categories. And a lot of the evidence categories, if you look at them, I can't remember the exact proportion, but it's significant, all relate to feedback in one way or another, whether it's feedback from service users, feedback from commissioners, feedback from stakeholders, feedback from staff. Now that is within a provider's gift to control in the run up to an inspection. It should be, as part of good governance, it should be something you're doing consistently anyway, but making sure that you're gathering that feedback, but also acting on it, and then demonstrating, recording somehow the way that you've acted on that and how that's led to positive outcomes for your service users. And if you can present that on inspection, you've got a much better chance. There's loads of good stuff going on in the homes and the services that I support, loads of it. But I think the problem is the feedback about it isn't gathered, or it is gathered and then nothing's done about it. How many times do I see services that send out surveys and that's it? They think, oh, we sent a survey 6 months ago. Oh, that's great. What did it say? What did you do? And how did you demonstrate that? And that's the type of thing that's within your control.
That's a good point. So I've been in some really good services that have boards that you said we did. Exactly. So that when they do their surveys, it's there, it's really clear. But just in terms of preparing staff, we had an inspection where an inspector spoke to me at one point and said, I've been to talk to this member of staff and asked them when the last time they did physical intervention training or restraint training, and they said they've never had anything. And I turned around to the member of staff and said, when was the last time you did skip training? Oh, I did that 2 months ago. Just how the question's phrased sometimes that can really make a difference in that. So I think you're right. Prepping staff, it has to be the major key.
It's fundamental, that, and making sure you're not going to get surprises about what service users and families are saying about the service. And if it goes back to, if you're gathering that feedback regularly, not everyone in your service is going to be happy at any one time. No one can please everybody, and there's always somebody that's not particularly happy, but you can guarantee that will be the person that the CQC inspector then comes and speaks to. So at least if you know what the issues are and you can demonstrate, you've taken steps to amend them, that's half the battle, rather than, again, being on the back foot, getting an inspection report, reading about it and thinking, who said this? Who said that? How do we sort that out? By that time, it's too late.
You then become a detective on who's that, rather than what the bigger issue is, So it's,
and that also adds loads of time to a challenge as well, because you will have seen, I'm sure, draft reports recently, but they're much shorter now. They're much more vague, and it is quite difficult to work out. One thing, and I have a real bugbear about this actually, is with regulatory breaches. CQC used to specify which regulation you'd breached and why. Now it just talks about breaches, and if you're lucky, it will tell you which regulation, but not always. And I think that's a wider problem that CQC really have to address as they start to do whatever it is they're doing with the single assessment framework. But in the meantime, it is tricky. And so if you think you are going to have to challenge, please make sure that you're asking for this specific feedback at the time of the inspection. They may fob you off. They may say, oh, we need to go back and look at it, etc., etc. But try your best to get as much feedback as you can on the day and keep a note of it, and start the process of gathering the evidence straight away. Because what I would say, I don't know what it's like now, and I know that CQC are committing lots of resources to speeding up reports being produced, but the most recent, or so, not the most recent, but some reports that I've challenged recently around about Easter time were for inspections that took place before Christmas. Now, memories fade, staff change, people pass away. So if you are then scratching your head in April about something that happened in December, that's going to be much more difficult. So do try and have a debrief after the inspection, anything that you think needs to be addressed, and send that to CQC. There's nothing to stop you giving that to them. What is an inspection window these days is pretty vague. It's really difficult to know when an inspection has started and finished under the single assessment framework, but you can supply evidence that you think was missing, and you should do it straight after an inspection rather than wait, and there's more chance of influencing it before it gets to a draft report.
Yeah, one of my previous bosses, he was from a legal background. He used to go on constantly about forming bundles. So your bundle starts at the point they walk in the front door. So set up a file that just has everything about that. And then when you need to do something about it, you've got it all there. Even if you don't need to do something about it, you've got a bundle that helps you reflect further down the line. So it's, some really good bits. So what common mistakes then do you see providers making when they're trying to challenge CQC outcomes? Some of the really glaringly obvious ones.
Well, some of them is where they haven't done anything at all to challenge. I last year was involved in a case which ended up, well, we managed to settle it thankfully, but it was on the brink of being at the Care Standards Tribunal for cancellation, and there was quite a tricky regulatory history. part of the issue was that they'd had some bad inspections, some warning notices, and rather than respond to them, they just buried their head in the sand. And that's quite a stark example of doing nothing. And then, at the other end of the spectrum in enforcement, it makes it very difficult to go back and say, well, that wasn't right at that time. CQC made a mistake if you didn't challenge it at the time. So that's a sort of bigger mistake. Other ones are not necessarily knowing what you can challenge and not bringing it back to the things that are likely to make meaningful change to the inspection report. It's all very well to set out that they've got the wrong number of service users. Minor mistakes, they're not realistically going to have a big impact on your rating or on regulatory breaches. So it's about looking at what they've said, looking at the impact, looking at CQC's guidance and how CQC are supposed to form judgments, and pushing back more on those terms so that it's more likely that some change will be made that's actually meaningful to your ratings. And part of that is providers just don't have a lot of experience of it. As I say, I'm doing it day in, day out. I have done for 10 years. I don't think there's much I've not seen that's not been challenged in an inspection report one way or another. But you touched on it earlier, providers are a bit nervous as well. So, and just because we would do an extensive challenge, it doesn't mean it needs to be aggressive, because I know that you might ask, and providers ask, oh, but if I do challenge, does that mean they're going to come down harder on me next time? Or, is it going to annoy my inspector? Is it going to damage the relationship? I mean, ultimately CQC is a professional body. It shouldn't, but there are ways and means to do your factual accuracy challenge as well, diplomatically and professionally, and that's something that we can talk about. But I guess those are the common mistakes: not knowing the extent of what you can challenge and the impact that will have. And I would commend providers that are thinking about doing it themselves, have a look at the guidance on CQC's website, because it is fairly clear about what you can challenge, what you can't, and what's likely to have an impact. But also look at breaches are particularly difficult, so look at them and have a think about that.
So just before we close then, I've added 2 parts to this one. You're already aware of the first part. Mm-hmm. So if you could give care providers just one piece of advice when it comes to dealing with CQC, what would it be?
Oh, it's don't panic. Don't panic. And I think that's from the top to the bottom, and it feeds into what we said about making sure staff members are trained and able to give the best account of themselves. If they know what to expect, if they know not to panic, then it's more likely that they'll give the best version of themselves. And equally, if you're a provider, you're a nominated individual, registered manager, the draft inspection report lands on your inbox or on the portal or however it comes in now, you're not happy with it, don't panic. You've got some time, you've got 10 days, start to gather your evidence and have a think about what you're going to do now.
Really good. So the same bit then, if you could give the CQC just one piece of advice when they're going through their current reorganisation, turmoil, whatever we want to call it, by the time the podcast goes out, with the new leadership and everything else, what would your advice to CQC be when dealing with providers?
Oh, that's so tricky to sum it up into one. You've really surprised me with that. Ultimately, everyone that I work with has a desire to provide good care and wants to be collaborative with the regulator. I think what would be lovely is if they revisited, there was a piece of guidance, I would say it was guidance, that they used to have on their website that lots of care bodies had fed into, and it was what to expect from a CQC inspection. And it was really clear about what providers, what registered managers and people using the service could expect when CQC came in. Yeah. It was really, really useful, and I think it has been withdrawn. I asked a question about it on a webinar recently, but it had some really just common sense procedural. It was a really good document if both parties were going to adhere to it, and it was all the things like making sure that you introduce yourself properly, you give the providers the opportunity to give any information they want to at the outset, making sure that people have the opportunity to ask questions if they don't understand, get feedback, get the opportunity to provide additional documents on the day. Just a framework so that providers could know what is an acceptable way for an inspection to run and what can we expect and what can CQC expect from us. I think getting that piece of documentation would be a practical help for both sides whilst they sort out the myriad of issues with the single assessment framework. Now, I'm not going to go into it in detail, but I've obviously spoken about reports are short, they're difficult to understand. And if you're saying that someone's in breach of a regulation, I think you have to put in the report what regulation they've breached and why. I think that's just basic. So there's a couple of things. There would be more. Yeah. I could do a whole podcast on it. A
couple of things, but common sense. We're not asking big things. We're just asking for clarity is probably what we're saying.
That's it.
Yeah.
And both, but I think mutual respect on both sides, because everyone's got the same goal in mind, and I think that there are professional ways to do it, and providers need to be less scared of CQC, and CQC, I think, maybe in some cases need to be a little bit more, or think about the impact that they have when they come in on a service, and how their sort of behaviour and demeanour can make staff feel, and is that going to give them the best version of the service.
Great way to finish. Thanks for joining me. I've really appreciated it, and I think people will listen to it and get a lot from it.
Perfect.
Well, that's it for this episode of the Care Social. Thanks for listening. If you found the podcast helpful, share it with your colleagues. If you want to find out more about Laura, check out her active LinkedIn profile. If you want to find more out about HCR Law, you can check out their website and LinkedIn profiles. Have a topic you'd like us to cover? Comment below or email us at qcs@qcs.co.uk. Until next time, bye for now.